Sections of the Canadian Constitution pertaining to Indigenous treaties. The Canadian Constitution recognizes and affirms the rights of Indigenous peoples, including those enshrined in treaties, through specific sections in the Constitution Act, 1982. These protections are essential for maintaining the legal and moral integrity of Canada's relationship with First Nations, Inuit, and Métis peoples. While the Canadian Charter of Rights and Freedoms outlines the rights of all Canadians, it also acknowledges that these rights must not diminish or override the distinct rights of Indigenous peoples. Two critical constitutional sections, Section 25 of the Charter and Section 35 of the Constitution Act, serve to protect these unique legal rights. Section 25 of the Canadian Charter of Rights and Freedoms ensures that the Charter cannot be used to abrogate or derogate from Indigenous rights. This clause was intentionally included to affirm that Charter rights are not superior to or in conflict with the rights and freedoms of Indigenous peoples. Specifically, Section 25 states, "The guarantee in this Charter of certain rights and freedoms shall not be construed so as to abrogate or derogate from any Aboriginal, treaty, or other rights or freedoms that pertain to the Aboriginal peoples of Canada." Government of Canada, 1982A. In essence, it acts as a protective clause that shields Indigenous rights from being eroded by broader interpretations of Charter rights. Section 35 of the Constitution Act, 1982, offers more explicit recognition and affirmation of Indigenous rights. This section, which is part of Part 2 of the Constitution Act, declares that the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Government of Canada, 1982b S 35(1). This provision is critical because it constitutionally entrenches these rights, thereby giving them the highest legal protection available under Canadian law. Section 35(2) further clarifies that the term Aboriginal peoples of Canada includes Indian, First Nations, Inuit, and Métis peoples. Furthermore, Section 35(3) states that treaty rights include rights from land claims agreements, whether modern or historic, and Section 35(4) confirms that these rights apply equally to male and female persons. Together, Sections 25 and 35 form a dual framework within Canada's constitutional structure. Section 25 operates as a safeguard within the Charter itself, ensuring that individual rights claims do not nullify collective Indigenous rights. Section 35, meanwhile, provides the substantive foundation for recognizing and affirming Indigenous rights, including those rooted in treaties, traditional practices, and modern land claim agreements. These sections have profound legal and political significance. They provide a constitutional basis for judicial decisions that uphold Indigenous land title, self-government, and other treaty-based entitlements. Courts have interpreted these provisions as requiring meaningful consultation and, in some cases, consent from Indigenous communities when their rights may be affected by government actions. As such, these constitutional protections remain pivotal in advancing reconciliation and justice within the Canadian legal system. In conclusion, the Constitution of Canada affirms the country's commitment to uphold Indigenous treaty rights through Section 25 of the Charter and Section 35 of the Constitution Act, 1982. These legal provisions not only protect Indigenous peoples from the erosion of their rights, but also establish a constitutional framework through which Canada must honor its historical and contemporary obligations to Indigenous nations. All citations are included in the descriptions of all these videos.